today about universal jurisdiction. A lot of the discussions we've had, the presentations we've had over the last day, or even over the last 2 days, have led us in the direction of universal jurisdiction, how we can use it, which cases have been filed, how to file them. So I have 10 minutes, so I can't deal with all of that, but we'll deal with some aspects, and then I'll talk through some cases that I've worked on and others have worked on in Africa to show you what's possible and that we don't need to go for 100% of convicting perpetrators all at once. We can move incrementally towards these cases and dealing with international criminal justice issues, and I'll talk through some of these. So, what is universal jurisdiction? I mean, I think you all know very well already what universal jurisdiction is. It refers to the idea that a national court may prosecute individuals for serious crimes under international law, and this you know also, crimes against humanity, war crimes, genocide, aggression, torture, based on the principle that such crimes harm the international community or international order itself, which individual states may act to protect. So I'll skim through. I won't go through all the detail, but I think if you'd like to have the slides, Wayamo can make them available for you. Universal UJ general principles is that the principle of universal jurisdiction is classically defined as a legal principle allowing or requiring a state to bring criminal proceedings in respect of certain crimes, irrespective of the location of the crime and the nationality of the perpetrator or the victim. Universal jurisdiction allows for the trial of international crimes committed by anybody, anywhere in the world. We'll get to some cases where you can understand how this has operated. We'll move along. The recognition of universal jurisdiction by the state as a principle is not sufficient to make it an operative legal norm. There are 3 steps necessary to get the principle of universal jurisdiction working, and this is the existence of a specific ground for universal jurisdiction, a sufficiently clear definition of the offense and its constitutive elements, and national law, national means of enforcement, allowing the national judiciary to exercise their jurisdiction over these crimes. So for Kenya, we've already spoken about the national laws, which means that universal jurisdiction cases may be brought in Kenya. We've had Pubudu already talk about the principle of complementarity. I won't go through it again. The autonomy of international crimes. In the prevention and punishment of international crimes, states are bound to observe the legal regime established by international law, both treaty-based and customary law. I'll move along a little bit so that we speak to some practical issues, but first just to speak about impunity and amnesties. Some of us have touched on this over the day. History has shown that amnesties have not been effective in achieving reconciliation, and they've helped make perpetrators believe they can violate as many rules as they want over and over again, and that finally they will be pardoned for their acts and forgotten. Conferring impunity is far from helping societies' reconciliation and strengthening democracy. It has served to divide more and generate contempt for the rule of law. So when we're talking about amnesties and impunity, we need to be very careful that perpetrators are not allowed to get away with having committed atrocious crimes, international crimes, without having some means of accountability for that. Examples of universal jurisdiction. So there's active personality jurisdiction, which is jurisdiction based on the nationality of the subject, of the suspect or the defendant at the time of the commission of the crime. Passive personality jurisdiction. This is jurisdiction based on the nationality of the victim at the time of the commission of the crime. And protective jurisdiction, which is jurisdiction over crimes committed against the forum state's own special interests. This is just a map showing you the countries which prosecuted international crimes in 2024. You'll see very few cases were brought in Africa, and we need to work together to ensure that that changes, that we need to file cases in our jurisdictions and get our courts and our judges to deal with these cases. Crime against humanity versus ordinary crime, what is the difference? What distinguishes a crime against humanity from an ordinary crime is the requirement that it must have been committed in the context of a widespread or systematic attack against a civilian population. And if we look at the case of Sudan, we can see very clearly that many of the crimes being committed are crimes against humanity. Okay, I'm going to talk through some cases now. How am I doing for time? Okay. So I've pulled up a lot of cases, but I won't be able to deal with all of them. So I'll deal with the most significant one in South Africa. It's the National Police Commissioner versus the Southern Africa Human Rights Litigation Center Trust. What happened in this case is that a civil society organization compiled a docket of a number of crimes that were committed in Zimbabwe by Zimbabwean nationals against Zimbabwean nationals. So they compiled a docket after having interviewed a whole range of witnesses. This was compiled and handed over to a prosecutor in South Africa. The prosecution service looked at the docket and said, we cannot take this case on. It concerns Zimbabwe and Zimbabweans, and it's not relevant here. So the civil society organization, this case went all the way from the High Court, the Supreme Court, to the Constitutional Court. Every single court agreed that South Africa can investigate and can prosecute these crimes committed in Zimbabwe and prosecute them in South Africa. So a really amazing, wonderful outcome, which you can use as a precedent in your countries to file similar cases. The case was finalized in 2014, and SALC, the NGO concerned, assisted the police at the time. The police said, well, civil societies don't know how to carry out investigations. This is police work. So they assisted the police to bring out every single witness from Zimbabwe to South Africa in order for the police to consult and carry out their investigation. They compiled their own docket. Since that time, not one single individual has been arrested. No prosecutions have commenced. So we have a wonderful, wonderful case and outcome, but we haven't seen any prosecutions, and it's unclear whether, as a result of this case and these individuals, we will see any prosecutions. But the case does mean that more universal jurisdiction cases can be filed in South Africa. So this is I wanted to speak about this case because it's an apartheid-era case, so an old case. There was a 47-year delay in prosecuting the individual who was the perpetrator in this case. He caused the death. He was responsible for the death of an anti-apartheid activist, Ahmed Timol. He pushed him out of a window of a police station and he died. And the police said, oh, well, he committed suicide. And that ended. There was subsequently a new inquest which said that this individual was one of the people responsible for killing him. And what was interesting about this case is that the National Prosecuting Authority agreed to prosecute this individual. He was a police officer. And what they did was they charged him with murder. And there were several CSOs involved in the case, and they said charging this individual with murder is insufficient. So there was an application for a recharacterization of the charge, and they asked for the charge to be amended so that it was not limited to the single crime of murder, but included the crime against humanity of apartheid, or alternatively, the other two charges. But it would have been, if the case proceeded, it would have been the first time that any individual would have been prosecuted for the crime of apartheid. Now, considering the 47-year delay in filing this prosecution, This individual died while the case was proceeding, so the case could never be concluded. But so, we don't know the outcome, but we have made the point that the crime of apartheid may be prosecuted even in very old apartheid-era crimes. Time is up. One more? Yeah? Okay. So this is Manuel Chang. He was the Mozambican finance minister, involved in a great deal of corruption. And the interesting thing about this particular case was how to deal with the conflict between treaty obligations. So the two treaties concerned was the SADC Protocol on Extradition, and the other treaty was the extradition treaty between South Africa and the United States. Mozambique requested this individual to be returned to his country, even though they hadn't filed any charges against him. And the USA wanted him to be extradited to the USA, and they'd had a number of charges pending for him. And the court went back and forth on this. The Minister of Justice made two different decisions with two different outcomes. Eventually, he was sent to the US, and he has now been successfully prosecuted. So it's not strictly universal jurisdiction, but it is related to those issues. I'll stop there. Thank you.